Hello friends, in this video I am going to discuss the Judges Inquiry Act 1968. Clause 4 of the Article 124 of the Indian Constitution states that a judge of the Supreme Court shall not be removed from his office except by an order of the President, passed after an address by each House of Parliament, supported by a majority of the total membership of that House and by a majority of not less than two-thirds of the members of that House present and voting, has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. I believe this explanation is very complicated, but stay with us. I will simplify while dealing this act. However, as defined in this provision, based on proved misbehavior or incapacity, a judge of Supreme Court or High Court can be removed. So in this video, I will discuss the procedure of judge removal described in the Judges Inquiry Act 1968. Before discussing about the procedure, let's discuss first what is the Judges Inquiry Act 1968 all about. It is an act enacted to regulate the procedure for the investigation and proof of the misbehavior or incapacity of a judge of the Supreme Court or of a High Court, and for the presentation of an address by Parliament to the President and for matter connected therewith. Now the next question is, what are the primary steps that need to be taken in order to initiate removal procedure of a judge? Under this act, the following steps defined. An impeachment motion against the judge of the Supreme Court or a High Court can be initiated in either of the Houses of Parliament. It may be Lok Sabha, that is lower house, or a Rajya Sabha, that is upper house. Such motion must be supported and duly signed by minimum 100 members. If it is initiated in Lok Sabha, however, if it is initiated in Rajya Sabha, then 50 members signature required. After signed by the minimum required members of Parliament, the petition needs to be submitted to a Speaker of Lok Sabha. If it is initiated in Lok Sabha, however, if it is initiated in Rajya Sabha, then Vice President, who is by default chairman of Rajya Sabha. Now, you might have the question, that is, what will happen after the submission of such motion in the Parliament? Once such motion is submitted in the Parliament, the Speaker or the case may be the chairman may, after consulting such persons, if any, as he thinks fit, and after considering such materials, if any, as may be available to him, either admit the motion or refuse to admit the same. However, if the motion is admitted, the Speaker or, as the case may be, the chairman shall keep the motion pending and constitute as soon as may be for the purpose of making an investigation into the grounds on which the removal of a judge is prayed for. For the investigation purpose, a Speaker Chairman shall constitute a committee. Now, you might have the question, that is, who will be the members of such committee? The committee consists of 3 members, of whom one shall be chosen from among the Chief Justice and other judges of the Supreme Court. One shall be chosen from among the Chief Justices of the High Courts, and one shall be person who is, in the opinion of the Speaker or, as the case may be, the Chairman, a distinguished jurist. Now, the next question is, what are the major functions of such committee? The committee shall frame definite charges against the judge on the basis of which the investigation is proposed to be held. Such charges, together with a statement of the grounds on which each such charge is based, shall be communicated to the judge, and he shall be given a reasonable opportunity of presenting a written statement of defense within such time as may be specified in this behalf by the committee. So it means once charge is framed against the respective judge must be given reasonable opportunity to prove himself or herself innocent in a given period of time. Furthermore, where it is alleged that the judge is unable to discharge the duties of his office efficiently due to any physical or mental incapacity and the allegation is denied, the committee may arrange for the medical examination of the judge by such medical board as may be appointed for the purpose by the Speaker or, as the case may be, the Chairman, or where the committee is constituted jointly by the Speaker and the Chairman by both of them for the purpose, and the judge shall submit himself to such medical examination within the time specified in this behalf by the committee. It means if there is any doubt, then committee can constitute a medical board to examine the facts and grounds of removal. Now, the next question is, what is the role of medical board? The medical board shall undertake such medical examination of the judge as may be considered necessary and submit a report to the committee stating therein whether the incapacity is such as to render the judge unfit to continue in office. However, if the judge refuses to undergo medical examination considered necessary by the medical board, the board shall submit a report to the committee stating therein the examination which the judge has refused to undergo, and the committee may, on receipt of such report, presume that the judge suffers from such physical or mental incapacity as is alleged in the motion referred to in this provision. So it means if judge refused the medical board for his examination, then the medical board can submit the report stating that the respective judge suffers from such physical or mental incapacity which is alleged in the motion. Now you might have the question, that is, what would be the result of medical board's report? The committee may, after considering the written statement of the judge and the medical report, if any, amend the charges framed under this act, and in such a case the judge shall be given a reasonable opportunity of presenting a fresh written statement of defense. Furthermore, the central government may, if required by the Speaker or the Chairman or both, as the case may be, appoint an advocate to conduct the case against the judge. Now, let's have some discussion on report of committee. At the conclusion of the investigation, the committee shall submit its report to the Speaker or, as the case may be, to the Chairman, or where the committee has been constituted jointly by the Speaker and the Chairman, to both of them, stating therein its findings on each of the charges separately with such observations on the whole case as it thinks fit. The Speaker or the Chairman, or where the committee has been constituted jointly by the Speaker and the Chairman, both of them shall cause the report submitted under this provision to be laid as soon as may be, respectively before the House of the People and the Council of States. Next, power of committee. Subject to any rules that may be made in this behalf, the committee shall have power to regulate its own procedure in making the investigation and shall give a reasonable opportunity to the judge of cross-examining witnesses, adducing evidence and of being heard in his defense. Now, you might be thinking, what will happen next? Now, following are the two possibilities. The committee finds judge in question is not guilty, or the committee finds judge in question is guilty. Now, let's discuss both possibilities in brief. The first possibility, that is, the committee finds judge in question is not guilty. If the report of the committee contains a finding that the judge is not guilty of any misbehavior or doesn't suffer from any incapacity, then no further steps shall be taken in either House of Parliament in relation to the report and the motion pending in the House or the Houses of Parliament shall not be proceeded with. So, the motion process will end here only. No further discussion. Next, the second possibility, that is, the committee finds judge in question is guilty. If the report of the committee contains a finding that the judge is guilty of any misbehavior or suffers from any incapacity, then the motion referred to in this provision shall, together with the report of the committee, be taken up for consideration by the House or the Houses of Parliament in which it is pending. Last but not the least, that is removal of judge. If the motion is adopted by each House of Parliament in accordance with the provisions of Clause 4 of Article 124 of the Indian Constitution, or as the case may be in accordance with that clause, read with Article 218 of the Constitution, that is regarding High Court's judge, then the misbehavior or incapacity of the judge shall be deemed to have been proved, and an address praying for the removal of the judge shall be presented in the prescribed manner to the President by each House of Parliament in the same session. Please focus here, in the same session in which the motion has been adopted. So, this is all about the Judges Inquiry Act 1968.